Hello everyone, and welcome to Trial and Error. My name is Crystal Widber, and I will be your host. This is our very first episode, and I am excited to launch this podcast where we will dive into some of the most fascinating and heartbreaking cases of miscarriages of justice. In each episode, I will explore wrongful convictions, forensic failures, and how the legal system sometimes gets it tragically wrong. My aim with Trial and Error is to shine a light on these cases, to share the stories of those affected, and to discuss how we can improve our justice system to avoid these mistakes, rather than going through trial and error numerous times. I'll also be joined by special guests along the way, including law enforcement and legal experts, to give us deeper insights into how these failures happen and how we can work to preventing them in the future. Today, we will be talking about the case of David Milgaard, one of Canada's most well-known wrongful conviction cases. David was just 16 years old when he was wrongfully convicted for the 1969 murder of Gail Miller in Saskatoon. But before we begin, allow me to introduce our guest for the day, a very special one at that, my dad, Carrie Widber. I thought there was no better person to kick off this podcast than someone who's seen firsthand how investigations are conducted. In this episode, we will discuss standard procedures in cases like the one we're talking about and what happens when things go wrong. So, Dad, thanks for joining me on this first episode of Trial and Error. Can you start by telling us a little about yourself and your job as a police officer?
Thank you. Well, my name is Carrie Widber, and I'm a happy husband to Candace and proud father of Crystal Widber. I've been a police constable for 29 years, getting my start with the Metropolitan Toronto Police Service in 1995 and being posted to 52 Division. Over the course of my almost 30 years, I've held many roles, including frontline patrol, scenes of crime officer, detective constable attached to criminal investigations, been part of an old closed unit, which is a fancy terminology for undercover street crime, community response, and many other roles. After 8 years of working in the city, I left Toronto and took a position with the Orangeville Police Service, and then ended with the Shelburne Police Service, coming back home to work in my lifelong community. In 2021, the Ontario Provincial Police and the town of Shelburne amalgamated, and I've been posted to the Dufferin Detachment of the OPP. I hold roles as a weapons systems armorer, SOCO officer, field coordinator for the Intoxilizer Breath Program, instructor and subject matter expert for e-ticket, radar, LiDAR, the Intoxilizer, ATVs, SMVs, just to name a few. I'm constantly looking for new areas to explore and to educate myself within the policing world.
So, would you say you've had your fair share of experience in investigating crimes and interrogating potential suspects? When we think about cases like David's, it makes me wonder how an investigation like this can take such a wrong turn. Could you walk us through the standard investigative procedures in a case like Gail Miller's back in 1969 compared to more modern techniques?
Certainly. Police were obviously alerted to the crime scene and attended the scene and the area. The area should have been cordoned off, quite a large area in fact. Scenes of crime officers or forensic investigators should have attended, photographing the scene, the body, clothing, and items in the area. Video probably didn't exist at that time, but video would have been a great asset. Clothing and the victim's body should be properly documented and preserved for follow-up inspection at the medical office or seized items at the local police laboratory. A canvass of the neighborhood should have been completed, asking people what they knew or possibly saw during the time of the offense. Evidence samples properly documented and stored. A local search of individuals who lived in the area, for lack of a better term, bad guys, that were local, should have been compiled and possibly spoken to. Given the investigative techniques that were taught to officers in 1968, I believe the initial units on scene did an adequate job.
That makes sense. Thanks for that insight, Dad. Now, with that in mind, let's start back in 1968. In 1968, Gail Miller had just moved to Saskatoon, Saskatchewan to take a job opportunity as a nursing student at City Hospital. On January 31st at approximately 6:45 a.m., Gail Miller left her house to head to the bus stop. At 8:30 a.m., Gail Miller's body was found in an alley a block from her home. She had never made it to the bus stop. She had been sexually assaulted and fatally stabbed more than a dozen times. Her blood-stained underwear and stockings were found near her left ankle. Her purse was found in a garbage can with its contents scattered in backyards close to where she was found, and the blade from a broken paring knife was found under her body. The police soon arrived at the scene of the murder after a child had found her body. The autopsy performed on her revealed that she had been slashed repeatedly in the throat and had stab wounds to her upper torso. She ultimately died from a stab wound to the lung. There was also semen found in her vagina, although the fluid that was removed was tested but never kept. The pathologist who had performed her autopsy gave police samples of Miller's hair, pubic hair, blood, and clothing. So, Dad, this is an interesting revelation. They had tested her vaginal fluid but never kept the sample. In a case like Gail Miller's, should they have preserved the sample? What is the standard procedure for keeping biological evidence from a crime scene, and what would be the consequences of failing to preserve a sample like this in modern investigation?
My initial answer to the question is, of course they should have kept and preserved the sample seized from Gail Miller. There are a number of tests that have been conducted on semen sample, including blood typing and DNA sequencing, but then we have to remember this is 1969, and DNA may have been discussed by scientists, but definitely not by police investigators and Crown attorneys. DNA was an unknown source for evidence at the time. In fact, DNA was first used as evidence in 1988 in Canada. I do believe the sample, or what remained after the sample was used for possible blood typing, should have been stored. Evidence collection today in regards to semen, blood, saliva, and other bodily fluids is collected and stored in CFS-approved vials by trained police or forensic identification officers. These samples are tested and processed by CFS staff and stored indefinitely. Failing to preserve this type of evidence would be detrimental to the case at hand. There may come a time during the case or court proceedings where this evidence could be used again and again.
Yeah, that checks out, especially considering how far forensic science has come since then. It's clear that evidence handling has drastically improved, but it's unfortunate that in cases like David Milgaard's, these advancements came too late to prevent a wrongful conviction. Surrounding Gail Miller's body were lumps of snow containing pubic hair and semen containing A antigens. They had also found semen stains in Gail's underwear. It was concluded that the knife found under the body was the murder weapon, but they couldn't find any complete or usable fingerprints on it. The police canvassed the neighborhood, interviewed Gail's roommates and coworkers, investigated known sex offenders, contacted the city's dry cleaners to see if anyone had brought in bloodied clothes, and much more, but none of which yielded any helpful information. It wasn't until March 2, 1969 that Albert Cadrain, David's friend, had gone to the Saskatoon police, telling them that he believed David had killed Miller. Milgaard and his friends, Wilson and John, arrived in Saskatoon at about 6:30 a.m. on January 31, 1969. Milgaard had been to Cadrain's house previously but didn't have the address, so all he could remember was that it was near St. Mary's Church, which is, as it turns out, about half a block from where Miller's body was found 2 hours later. The trio had stopped to ask a woman for directions, but she could not help, and as it was just their luck, their car had gotten stuck in the snow. The trio couldn't dislodge the car, so Milgaard and Wilson had gone in opposite directions to look for help, while John stayed with the vehicle. Ultimately, when Milgaard and Wilson returned, 2 men helped them push their car out of the snow. They didn't see anything unusual about Milgaard or any blood on his clothes. The group arrived at Cadrain's house around 9 a.m. Milgaard had ripped the crotch of his pants, and they had holes from where battery acid had spilled. Both he and Wilson changed their clothes, and Milgaard drove around the block by himself a couple of times because he liked driving when the car had stalled once more outside of Cadrain's house. Once the car was repaired, the group traveled to Edmonton. While driving, John opened the car's glove box and found a woman's compact, questioning Milgaard about it. Milgaard grabbed it and tossed it out of the window, claiming that he had no idea where it came from. He later admitted he didn't know why he threw it. The group had returned to Saskatoon on February 6, finding out that Wilson's father was ill, when the police picked up Cadrain and charged him with vagrancy. When the police had learned that he had lived in the same neighborhood where Gail Miller had been murdered, they asked him about it, to which he said he hadn't heard about it. Cadrain learned the details of Miller's death when he arrived home in Saskatoon on March 1st, and his family told him about it. The police at the time had no leads, but they were under pressure to solve the case and had posted a reward for information leading to the killer. Dad, how does media pressure and attention impact ongoing investigations? Have you ever experienced that sort of pressure, and if you have, what is that like?
Well, I've been fortunate that I haven't experienced that particular pressure with my investigations. But media attention and public pressure can affect police investigations in a number of ways. Media coverage can impact how the public views police investigations. News coverage can influence how the public understands our criminal justice system. Public misconception of how investigations are conducted, combined with a fear of a hardened criminal or killer loose on the streets, would potentially lead investigators to rush to conclusions and to rush their investigations. A rushed investigation is a sloppy investigation, and this will lead to mistakes being made, as I'm sure we will hear about during this podcast.
That's a really important point. Media coverage and public perception can certainly put added pressure on investigators, potentially leading to rushed or biased conclusions. I think David Milgaard's case is a strong example of how public fear and expectations might contribute to a sense of urgency that can, unfortunately, overshadow thorough investigation practices. Cadrain went to Saskatoon police the next day, claiming that he saw blood on Milgaard's pants on January 31st and that his friend seemed to be in a hurry to leave town. Lieutenant Charles Short and Detective Eddie Karst questioned him and took his statement. During his 2-hour interrogation, Cadrain told police that on the day of the murder, Milgaard arrived unexpectedly at his house at about 9:05 a.m. and said that they had to leave town right away. Cadrain told them that he saw blood on Milgaard's shirt and pants before he changed his clothes and took Wilson's car for a drive by himself. He also claimed that Milgaard talked a lot about cleaning the car and that others in the car seemed to be afraid of him. On March 3rd, Karst questioned Milgaard and told him that he was a suspect in Miller's murder. He asked David to account for his whereabouts on January 31st, 1969, to which David talked about stopping a woman in the street and going to a motel to get directions, getting stuck in an alley, and changing his clothes because they had battery acid on them. Although he was cooperative, he was vague, as he couldn't remember what time the various activities had taken place, he didn't know where his clothes were, and they didn't turn up during a police search. There was also no scratches or marks on his body consistent with what one might expect to find after a recent struggle. David had also told police that he drove Wilson's car around the block after reaching Cadrain's house, stating that he likes to drive, I guess. He explained that the reason he had been in a hurry to leave town was because he was excited about seeing his girlfriend in Edmonton. He also had admitted that he had taken drugs during the road trip and had received previous psychiatric treatment when he was 13, and he tended to make impulsive decisions. Karst questioned him further, asking if he had a criminal record, to which Milgaard admitted he had convictions for sexual immorality, trafficking, stolen cars, breaking and entering, escaping lawful custody, and that he had been deported from the United States. Now, Dad, in talking about witness interviews, what is the standard procedure for questioning a suspect and investigating a crime scene? If you were the one questioning Milgaard, would you say, given this admittance in the situation as well as the pressure from the public, that your suspicions against Milgaard would grow?
Again, we have to remember this is 1969, and at that time police investigators would speak to witnesses and suspects in a very different manner than today. Today, the Charter of Rights and Freedoms of Canada are in place, and those having come into effect in 1982, ensuring a person's right to be presumed innocent until being proved guilty. Today, an accused person, and in some instances a witness to an offense, must be advised of their right to remain silent, a right to have a lawyer present, along with several cautions in regards to what these people may say or do during an interview. Witnesses and suspects must be advised that their statements and any evidence collected would be used in a court proceeding. This is in stark contrast to what practices were in place in 1969, where repeated and lengthy interrogations took place and on multiple dates. And police conduct, which was the norm at the time, would undoubtedly be considered harsh and threatening today. However, given the information obtained from Milgaard at that time, I do believe my suspicions of him being part of this crime would grow.
Right. It's clear that investigation methods have come a long way, especially in terms of protecting individuals' rights during questioning. In cases like Milgaard's, it's interesting and sad to see how different things might have been if today's protections were in place. The right to legal counsel and the cautionary reminders we give now can make a huge difference in ensuring fair treatment. Although, admittedly so, it would be hard to not be suspicious of Milgaard, but this would be a form of contextual bias, where you are basing your decisions and thoughts given this new context and information, when you rely too heavily on an initial piece of information when making subsequent decisions. Now, bias in the judicial system is inevitable. How do you go about conquering or avoiding bias? Do you find that you are subconsciously making decisions based on your biases?
To minimize bias, investigators should adopt an evidence-based approach, relying on objective and relevant information only. They must ensure that the evidence is collected from multiple sources and that statements are corroborated wherever possible.
Thanks for highlighting that. It's important to rely on an evidence-based approach to help keep investigations fair and balanced, ensuring that personal opinions don't steer the case in the wrong direction. Although David had not been convicted of a violent crime, Karst's interest in him as a suspect in Miller's murder grew. The teenager was in the vicinity at the time of the crime. He was driving in back alleys that morning, was at the Cadrain residence a block from where Miller's body was found. He and his companions were under the influence of drugs. He had a criminal record, and Milgaard tried to clean Wilson's car while it was being repaired. Milgaard denied there was blood on his clothing, but police couldn't find the clothes in question to either support or disprove that statement. Dad, what role does evidence collection play in determining a suspect, and how does it guide investigations? How are witness testimonies verified or corroborated with physical evidence? Would you say that having physical evidence plays a crucial role in swaying the investigation and possible suspects?
Evidence collection is critical in determining a suspect because it can physically link that suspect to a crime or crime scene. This evidence can help investigators reconstruct the sequence of events in a crime scene. It can ultimately establish whether a suspect is guilty or innocent. Witness statements and testimonies are verified by investigators with follow-up investigations. Investigators would try to verify what information was given to them by obtaining information from other witnesses or people that may have been in the area. Today we would interview the witness, and then anyone the witness may have spoken to see if the information is similar. Video footage and surveillance is key to investigations now. In the end, having physical evidence that places a suspect at a scene, near a scene, samples of that suspect on a victim in some manner, would ensure the investigation wasn't swayed in a particular way and would confirm that the person we are investigating is in fact the primary suspect.
Right, and I think that it really shows how essential strong evidence collection is to an investigation, especially when it comes to linking a suspect to a crime. It's also clear how critical it is to corroborate witness statements and ensure that all information aligns, without letting the investigation get steered in one direction too soon. Now, while Milgaard was being interviewed by Karst, Wilson was being questioned at the same time, confirming that they had arrived in Saskatoon between 5 and 6 a.m. Their car got stuck in an alley, they got a boost to their car, and finally made it to Cadrain's house. Wilson said that after they had arrived, Milgaard changed his pants because of spilled battery acid, and that Milgaard was never out of their sight for more than an hour. Wilson didn't see any blood on his clothing. Nicole John was then questioned more than a week later, when she had initially supported Wilson's statement. Both Wilson and John told police that their friend had no opportunity to commit the crime. Cadrain, whom they met up with later, was the only one to suggest that Milgaard had been involved. A week later, they interviewed John and Cadrain together, and unsurprisingly, John's story began to change. She told police that she was afraid of David and that he was dangerous. When John was interviewed a third time, her story changed again. She insisted that Milgaard and Wilson hadn't been out of her sight the day of the murder, and she didn't see any blood on his clothes, but she did think he was capable of sexual assault and murder. When Saskatoon police interviewed Milgaard on April 18th, he was very cooperative and willing to give blood, saliva, and hair samples, as he was eager to help and clear himself. Unfortunately, David turned out to have type A blood, which was the same as the sperm found near Miller's body. Milgaard denied killing Miller or being involved in her death, but he was not eliminated as a suspect. Police had no evidence linking Milgaard to the murder. They needed to either find some evidence or eliminate him as their prime suspect. In May 1969, under the strain of repeated questioning, Milgaard's friends began to change their stories. Wilson told the police that Milgaard had left the car when they became stuck at about 6:45 that morning, and when he returned, he seemed to be out of breath. According to the inquiry report on the case, he showed John some of Miller's bloodied clothing and appealed to her sympathy by asking her, "What if this had been your sister?" That's when John began to incriminate Milgaard, stating that she suddenly remembered seeing him stab the girl they had asked for directions moments before the murder happened. She never repeated this claim again. Now, I find this kind of odd. So, Dad, during witness interrogations, are investigators permitted to present evidence to witnesses? If so, what are the guidelines or limitations around when and how evidence is shown to prevent influencing their testimony?
Investigators are allowed to present evidence to witnesses. Typically, they will only show the witnesses any evidence that's been released via police bulletin, media reports, social media, or information that's public knowledge. Photographs from the scene or area would be provided to refresh the memories of the witness, and they would be asked to discuss what they see in the photo. The investigator would present them with the evidence and not fill in any gaps for them. Investigators are supposed to allow the witness to think and say what they see. Investigators are not to provide input, as this may influence their testimony. Everything the investigator does must be documented and disclosed to the courts.
So it sounds like investigators have to be really careful when presenting evidence to avoid influencing witnesses. Letting the witness interpret the evidence on their own seems crucial to maintaining objectivity in their testimony. For his part, Wilson said that the maroon paring knife found near Gail Miller's body was similar to the one that Milgaard had with him on their road trip, that he'd seen blood on Milgaard's pants when he was changing, and had recounted the situation when Milgaard tossed the woman's compact out of the car window, even though Miller's compact was found in her purse along with other items. It's not clear as to why the teenagers suddenly changed their stories, but it proved to have devastating consequences for Milgaard. Police arrested Milgaard on May 30th, 1969, and the pressure to find Miller's killer was finally over. The police did not disclose to the Crown that they had initially believed that the same person was responsible for Miller's murder and the string of sexual assaults that preceded it. As was police practice at the time, they only sent the prosecutor the reports and witness statements that they felt were relevant to the case. Milgaard's trial by judge and jury began in Saskatoon Court of Queen's Bench on January 19, 1970, before Chief Justice Alfred Bentz. Crown witness Sergeant Bruce Painter testified that the frozen semen found at the crime scene was from someone who had type A blood and secreted antigens into bodily fluids such as semen and saliva. Milgaard had type A blood, but no antigens were found in his saliva. This suggested that he was not a secretor, and the semen the police tested was not his. Tallis argued that Milgaard therefore could not be the person whose semen was found at the crime scene, and this forensic evidence exonerated him. However, testimony from Milgaard's friends suggested otherwise. Wilson, who initially told police that Milgaard was never away from the car for more than a minute or two, testified that he left the vehicle for more than 15 minutes. The Crown's theory was that this was when Milgaard fatally stabbed Gail Miller. Although Wilson told police that he didn't see any blood on Milgaard's clothes, he testified during trial that he saw blood on Milgaard's pants and shirt. Cadrain testified that he saw a bloodstain that was 1 or 2 inches in diameter and a few spatters on Milgaard's pants and shirt tail. John testified that she couldn't remember saying that Milgaard had stabbed Gail Miller. This was inconsistent with the police statement she had given in May. In the presence of the jury, Crown Prosecutor T.D.R. Caldwell was allowed to read portions of John's police statement in which she claimed to have seen Milgaard stab a woman. When asked if her statement was true, John replied that she didn't know. Although the judge warned the jury to only use the parts of John's police statement that she had adopted on the stand, the damage was done. They had heard her police statement incriminating Milgaard. Dad, in this case, the jury heard conflicting testimony from John, who couldn't remember her previous statement, yet her initial police statement was still read aloud in court. How do police and legal teams typically handle situations where a witness's court testimony contradicts their earlier statements? Should there be more caution in presenting such statements to avoid prejudicing the jury?
All evidence collected, including statements, must be disclosed to both the Crown Attorney and Defense Counsel. Everything. So in this case, the first statement, taken along with any follow-up statements, must be disclosed. Typically, Crown Attorneys or their team would review the statements and find any instances where the information may conflict. Once these conflicts are identified, further statements or meetings would take place in an attempt to clarify the issues with the witness. In this case, the first statement and conflicting statement would have to be presented. And a good defense team would argue that 2 different versions of events have been presented, and possibly bringing the initial testimony into question. A jury would be instructed to make their own decisions as to what versions of events they believe. The hope is that the jury would recognize the discrepancies brought forward and come to the right conclusion.
Got it. So it's all about transparency and ensuring both sides have the full picture, especially when witness statements don't align. It's helpful to know that any discrepancies can be used by the defense to question reliability, and it's up to the jury to decide which version they believe. At the time, David didn't testify in his own defense after the Crown presented 44 witnesses, as his lawyer believed that Milgaard's drug use and previous brushes with the law would not make him a good witness. Milgaard was convicted on January 31, 1970, and sentenced to life in prison with no chance of parole for 10 years. He was 17 years old. As his mother Joyce recounted in an excerpt from her book, A Mother's Story, David's conviction had an impact on the entire family. They lived in a tiny community in Saskatchewan of about 1,000 people. David's quiet 15-year-old brother came home showing signs of having been in fights. 14-year-old Susan suddenly no longer had friends. And children surrounded 10-year-old Maureen and taunted her with, "Your brother is a killer." By May 1970, it became clear that the family would have to move. The Saskatchewan Court of Appeal rejected Milgaard's appeal in January 1971, and the Supreme Court of Canada followed suit on November 15th. He had reached a legal dead end. But Larry Fisher's involvement with the criminal justice system had just begun. At the time of Gail Miller's murder, he lived in the basement apartment of the Cadrain house with his wife Linda and their infant daughter Tammy. 3 weeks after Milgaard was convicted, a fourth victim was followed home and raped in Saskatoon on the evening of February 21st, 1970. Another woman was assaulted in Fort Garry, Manitoba on August 2nd. Fisher was arrested in Fort Garry on September 19th while he was raping his sixth victim. He had no criminal record. The Saskatoon police were alerted since Fisher had previously lived in that city. During an interview with the Saskatoon police, Detective Eddie Karst in Winnipeg on October 22, 1970, Fisher confessed to 2 of the assaults in Saskatoon. 2 months later, on December 30th, a month after Milgaard appealed his murder conviction to the Saskatchewan Court of Appeal, Fisher was charged with raping 3 victims in Saskatoon and 1 indecent assault. On May 28, 1971, he pled guilty to raping his final 2 victims in Manitoba, for which he was sentenced to 13 years in prison. On December 21st, he pled guilty to the 4 Saskatoon attacks and was ordered to serve his sentence concurrently with his 13-year sentence in the Manitoba attacks. In 1971, Crown Prosecutor Serge Kujawa handled Milgaard's leave to appeal to the Supreme Court of Canada and Fisher's guilty plea in Saskatchewan Court of Queen's Bench. But neither the police nor the Crown made a connection between the series of rapes and Gail Miller's murder in the same neighborhood around the same time period. Fisher was released from prison on January 26, 1980, after serving 10 years of a sentence, and was sentenced in June 1981 to 10 years in prison for rape and attempted murder. Fisher's first convictions 10 years earlier had aroused the suspicions of his ex-wife, Linda Fisher. In 1971, she confronted him while he was in prison, but he denied that he had killed Miller. His denial, nor the fact that Milgaard had been convicted, didn't ease her suspicions. She even went to the public library to look for a picture of the murder weapon that was used in Miller's killing. She wanted to compare it with her missing paring knife. In August of 1980, Linda Fisher went to the Saskatoon police and told them that she suspected that Larry Fisher was Gail Miller's killer. She thought David Milgaard was innocent. She gave her statement to Inspector Kenneth Wagner, the senior officer on duty. She told him that she was in the midst of an argument with Larry Fisher the day of Miller's murder when a news story about the killing came on the radio. She said that he was shocked when she accused him of killing Miller. She also stated that she lost a paring knife around the same time and believed that Fisher might have used it in the killing. Larry Fisher had never been questioned about the murder. Her statement was sent to the police department's investigation division, but nobody followed up. It proved to be another missed opportunity to write a wrongful conviction. It would take another 17 years for Larry Fisher to be linked to Gail Miller's murder. Now, Dad, in regards to statements, how should police typically handle statements like Linda Fisher's, and what kind of follow-up should be done when new information comes in after a case has already been closed?
Information of this nature does occur. That is, information provided shortly after a matter, or in this case, quite some time has passed. The statement should have been handled by investigators who had worked the original case, or the information should have been forwarded to those initial investigators. Follow-up should have been done to confirm if the information was credible. This new information should then have been provided to the Crown Attorney's Office for review, in the hopes that they would also conduct some sort of follow-up to corroborate the information and, if possible, bring it forward for a judicial review.
So, ideally, any new information, even if it comes in years later, should be handled by the original investigators or forwarded to them for a proper follow-up. It sounds like there's a real importance in verifying new statements and making sure the Crown is informed to consider any necessary judicial review. While Milgaard waited for his appeals to run their course, he became depressed and attempted suicide. Prison officials felt that he needed to take responsibility for Gail Miller's murder in order to be considered rehabilitated. Since he continued to maintain his innocence and refused to admit to a murder he didn't commit, he was repeatedly denied parole. As difficult as it was to be behind bars, Milgaard wasn't ready to trade his innocence for his freedom. Milgaard went to visit his family on a temporary pass in August of 1980, and amid the excitement of a family barbecue to celebrate his brother's birthday, he escaped to Toronto. Under an assumed name, he found an apartment and a job, but his freedom was short-lived, and on his 77th day of freedom, the RCMP shot him in the back. As Joyce Milgaard sat with her son, handcuffed to his bed in St. Joseph's Hospital, she knew she needed to take action. Joyce Milgaard issued a news release in December 1980 offering a $10,000 reward for information that would prove David's innocence. She bought court transcripts and, with her family, pored over them looking for holes in the Crown's case. Supporters began to rally around her. In 1986, Joyce Milgaard gave well-known criminal lawyer Hirsch Wolch her last $2,000 to review the court transcripts to look for grounds to apply to the federal justice minister for the mercy of the Crown, under what was then Section 617 of the Criminal Code. This provision gave the minister the sole discretion to order a new trial or give Milgaard another chance to appeal his conviction. Finding enough compelling evidence to prove Milgaard's innocence and persuade the minister to overturn his conviction proved to be an overwhelming task. DNA testing and its application to criminal cases was just beginning to emerge. The Milgaards tracked down Vancouver forensic pathologist Dr. James Ferris. The field of DNA testing was not sufficiently advanced for him to help, but he did point out that the semen samples referred to during her son's trial were collected 4 days after the murder. This meant that they were very likely contaminated after being trampled. Dad, since the semen samples were collected 4 days after the murder, raising concerns about contamination, how are biological samples like this typically handled at a crime scene to prevent contamination, and what procedures are in place today to ensure that evidence remains viable for testing over time?
As previously stated, evidence on scene is collected by trained forensic investigators, and it should be collected as soon as possible. These investigators are trained on how to properly collect, document, store, and transport evidence of this nature. The samples are stored in-house as per police agency policy, or sent to proper laboratories such as the CFS, where they're stored in accordance with provincial standards, which means they could be held for a very long time and in a manner in which they will not become contaminated or degrade.
It sounds like these processes are designed to protect evidence integrity from the start. Having trained forensic investigators handle the collection and storage means samples are kept under strict conditions. It's good to know these standards are in place to preserve evidence long-term, in case it's needed again for review. Dr. James Ferris also concluded, as had argued Milgaard's trial lawyer, that serological evidence failed to link Milgaard to Miller's murder. On December 28, 1988, nearly 19 years after Milgaard was convicted, his lawyers applied to have the federal justice minister reopen his case. It was based on an affidavit from Hall and Ferris's report. Joyce also enlisted the help of Paul Henderson, an investigator with Centurion Ministries. Henderson tracked down Ron Wilson in British Columbia. Wilson recanted his testimony implicating Milgaard. He admitted that under repeated police questioning, he'd wanted out, so he had finally told the police what they wanted to hear. Here's another question for you, Dad. In David Milgaard's case, the police seemed to focus almost exclusively on David Milgaard, leading to repeated questioning of his friends, resulting in them telling the police only what they wanted to hear. How does tunnel vision affect an investigation, and what measures are in place to ensure investigators avoid focusing too narrowly on a single suspect, especially when questioning witnesses multiple times?
Tunnel vision can significantly impact police investigations, causing investigators to focus too much on a single suspect or a theory, which can then lead to a biased decision and mistakes. Investigators may overlook other suspects. They may downplay or disregard evidence that doesn't support their theory. They may not seek out evidence that doesn't support their theory or possible alternative events. With current investigations, there are a number of different investigators assigned to each case. All are tasked with reviewing the matter, and weekly group discussions are held with numerous investigators, including ones that are not even involved with the current case. In an attempt to get all the ideas and theories out into the open, investigators are encouraged to voice their opinions and differences that they have regarding the investigation, and this ensures that all areas and all possible outcomes are discussed.
It's reassuring to know that current practices include regular group discussions with multiple investigators, even those not directly on the case, to review all possible angles. On February 27, 1991, Campbell turned down Milgaard's request to reopen his case. The forensic report presented in the application was deemed to be similar to the argument that Milgaard's lawyer had made at trial, and Wilson's recanted testimony was considered unreliable. His application for parole was refused yet again the following month. He had now spent nearly 22 years behind bars. While the federal Justice Department was reviewing Milgaard's application, his lawyer, Hirsch Wolch, received an anonymous phone call on February 26, 1990. The caller said that Larry Fisher was Miller's killer. The RCMP subsequently investigated Fisher, but could find no physical evidence, confession, or witness that would give them a reason to charge him with murder. Nonetheless, this opened up a new avenue for Milgaard's lawyers to explore. They submitted a second application to the Justice Minister, and it focused on Larry Fisher as the perpetrator of the string of sexual assaults in Gail Miller's neighborhood prior to and immediately after her murder. It suggested that this information would have been admissible in David Milgaard's trial if the information had been known and available at the time. Miller's family joined Milgaard's in calling for a fresh look at the case. Milgaard's supporters used a media campaign to gain public support for review of his case. Since authorities didn't seem to be listening, they hoped that public support for his pleas of innocence would get attention for his case and influence the Justice Minister. On September 7, 1991, they held a candlelit vigil outside a Winnipeg hotel where Prime Minister Brian Mulroney was expected. When Mulroney stepped outside of his car, he was greeted by Joyce Milgaard and spoke with her briefly. She told him that her son's emotional state was deteriorating and asked if the Prime Minister might help get him transferred to a smaller prison located closer to family. She also asked if a speedy review of his case was possible. Mulroney told her she was courageous, and a month later, David Milgaard was transferred to a minimum security prison. Dad, as a police officer who has worked in the force for almost 30 years, you've probably had your fair share of working with individuals who struggle from numerous mental health issues. How does long-term incarceration, especially for someone wrongfully convicted, affect a person's mental health, and what kinds of mental support are available in prisons today for inmates struggling with emotional or psychological issues?
Long-term incarceration can have a serious impact on mental health, and the effects can last a lifetime after release. Post-incarceration syndrome, which is similar to PTSD, can cause a range of symptoms including distrust, alienation, and social sensory disorientation. Difficulties in maintaining relationships, problems in making decisions, depression, mania, and substance abuse. Now, I'm not an expert, but I have done some research, and I can say that inmates incarcerated in Canada have access to mental health screening, on-site care, transitional care for when released, transitional planning, housing assistance, spiritual and religious care, along with recreational activities in the institution. Canada is a leader in inmate mental health care.
It's clear that long-term incarceration can deeply impact mental health and conditions like post-incarceration syndrome, making reintegration incredibly challenging. I'm glad to hear that Canada prioritizes mental health care for inmates, including transitional support and planning for release. It's reassuring to know that these mental health resources are available. The Justice Minister referred Milgaard's case to the Supreme Court of Canada on November 28, 1991. This time, Milgaard testified during the hearings. Ron Wilson recanted part of his trial testimony, and Milgaard's lawyers presented the pattern of assaults committed by Larry Fisher. On April 14, 1992, the Supreme Court of Canada, citing Wilson's partial recanting of his trial testimony and the string of sexual assaults committed by Larry Fisher, recommended that Milgaard's conviction be overturned and a new trial be ordered. The Supreme Court justices believed that the evidence could have affected the verdict at Milgaard's trial and had it been available at the time. They also ordered that he be released. Milgaard emerged from prison after 23 years behind bars. He was just shy of his 17th birthday when he was arrested and was now 39 years old. But he hadn't been acquitted nor exonerated for the murder. The Saskatchewan government's Attorney General said there would be no commission of inquiry, nor would Milgaard receive compensation because his innocence had not been established by the Supreme Court of Canada. At the time, the guidelines for compensation for wrongful conviction required proof of innocence. Fisher was released from prison on May 26, 1994, and 3 years later, DNA testing had advanced sufficiently to give the technology another try. A test was performed on the semen found on Miller's clothes, and on July 18, 1997, the results revealed that the semen on Miller's clothing didn't match Milgaard's, but it did match Fisher's. He was arrested on July 24th and charged with her murder 28 years after she was stabbed to death in a Saskatoon alley. Fisher was convicted on November 22, 1999, and was sentenced to life in prison on January 4, 2000. A month after Milgaard was exonerated, the Saskatchewan government announced that he would be compensated for his wrongful conviction, to which he was awarded $10 million. They also made a commitment to hold a public inquiry into the circumstances that led to his wrongful conviction. The Commission of Inquiry into the wrongful conviction of David Milgaard got underway on January 17, 2005. The inquiry examined the investigation into Gail Miller's murder and David Milgaard's trial, the information that emerged after Milgaard's conviction, how the case was reopened, and whether the investigation should have been reopened when police and justice officials received new information. It also examined systemic issues that led to Milgaard's wrongful conviction. Saskatchewan Justice Minister Don Morgan released the Commission's 815-page report on September 26, 2008. Justice McCallum believed that the Saskatoon police acted in good faith during its investigation of Miller's murder, but he raised questions about how detectives questioned Ron Wilson and Nicole John. But for the questioning of John and Wilson, David Milgaard would not have been charged and tried for the crime of the murder, McCallum said in his report. He didn't believe that investigators induced John to lie about seeing Milgaard stab a woman. Rather, she may have been pressured to tell them what they wanted to hear. He was also critical of the trial judge, who incorrectly applied a rule of evidence, which led to the jury hearing information that prejudiced the case against Milgaard. The judge also intervened repeatedly when witnesses were testifying, which had a similar effect. McCallum noted that the Saskatoon police should have investigated Linda Fisher's statement that she believed her ex-husband was responsible for Gail Miller's murder. He said that whether or not to follow up on these types of reports should not be left up to the discretion of the police. Among his 13 recommendations, he also called for the federal government to create an independent body to review allegations of wrongful convictions. Had such an agency been in place in 1980, the investigation into the death of Gail Miller would probably have been reopened, McCallum wrote in his report. Wow, well that brings us to the very end of our very first episode of Trial and Error. The story of David Milgaard is a powerful reminder of the flaws that can exist in our justice system and how vital it is to follow proper procedures, question assumptions, and avoid tunnel vision during investigations. It's important to remember that wrongful convictions don't just affect the person imprisoned, they ripple through families and communities. With that, thank you for joining me today as we took a deep dive into this tragic miscarriage of justice. I hope that by sharing these stories, we can continue to push for improvements in our justice system. Until next time, I'm Krista Widber.
And I'm Carrie Widber.
And this has been Trial and Error, where we're shedding light on wrongful convictions one case at a time.